Well, thank you all for coming out. It is a tremendous honor to be able to speak at a site like this. So thank you all for coming here. Thank you for Allison for thinking of me. The topic of tonight's conversation is something that came up several times with my wife, who used to work at the Fort Bend Museum. And it was really talking about how a lot of the land passed through the maternal lines and how that came about. And some of that we cover in law school. Some of it's just me being a geek. But it really is an interesting topic, and how much the frontier and really the realities of Texas put Texas at the forefront of a lot of laws that were more favorable to women. So it's kind of cool tonight, starting off Women's History Month, that we're going to be able to talk about a lot of this. But being a lawyer, before I begin, I've got to throw out a few caveats. So the first caveat is who we're talking about. Because when we talk about the laws at the time weren't equal. So the laws that we're going to discuss only applied to Anglo women and Tejano women. They wouldn't have applied to the enslaved, nor they've applied to the Native Americans. That had to wait for a long time. Bigger presentations on that should be done at a later date. The time frame that we're looking at is roughly from about the time of Mexican independence in 1821, about to the Civil War. That time period is when Texas really forms what would become the foundation of our laws. It's also a period when it's unsettled, things are a little bit wild, and the frontier conditions are in place, which allow the laws then to adapt to those circumstances. Lastly, we're not going to be going all that deep. We've got a lot of ground to cover, and so I'm not going to be going through a ton of case law, through statutes and all of that. We're going to hit the high points. And my approach to this really is not as a lawyer who practices in this area looking backwards. I'm more of an amateur historian who happens to speak legalese. So there's going to be a lot of history explaining the law as it existed. So one thing to understand, and that I think we always miss as Texans, is how vast the state of Texas really is. We joke about it. We talk about the mileage when you hit the sign at I-10 in Beaumont. But until you put it on a map, you don't realize we're the size of France. When the early colonists came in the 1700s, and then even up to the old 300, even up until statehood, this whole area had a smaller population than Cinco Ranch just down the road in Katy. And so when you think about that and you spread that group of people out across that area, it was very, very distant, which plays into all of how this works out. So the concept in addressing all this really begins in 1821. Mexico wins its independence from Spain, realizes there's a ton of territory. Now they know that Texas has vast natural resources. They know they can work it for a profit. And coincidentally, it'll also help serve as a barrier from Native American attacks down into the interior of Mexico. So what do we do about it? Well, they turned to a system that had worked somewhat for Spain before. Earlier in the late 1700s, the Spanish had recruited American settlers to move into Missouri, Arkansas, and Louisiana. So if you know Daniel Boone did not die in Kentucky because he took his family and all of their friends and moved to Missouri. And they settled that land. And so the Spanish had set an example that this might work. And so they think they're getting families like this, your classic Scots-Irish settlers, always pushing west. Maybe they adopted Catholicism, maybe not. The problem is they didn't get this family, they got this guy. So if you've ever read any of Stephen Hardin's books, this guy shows up quite frequently. The reality of the situation is that once they open it up for immigration, overwhelming numbers of single men show up. It's not what they anticipated. They thought it would be more families. Stephen F. Austin obviously had the 300 and they were spread out. But if you look at the actual numbers, it's overwhelmingly male. And yeah, they took the promise to accept Catholicism, to convert. That's great, except you got to have a priest to actually convert them. There weren't many of those on the frontier. Same thing, to the extent there was law, there's not exactly a lot of law enforcement when your neighbor's 25 miles, not even down the road, because there weren't any roads. So this is a different environment. It's a tough environment, and it's overwhelmingly male. So at this point, you're probably asking yourself, I thought he was going to talk about women. How on earth is this going to work out? Women had a different reality. Those that came found a different situation that was every bit as hard, if not harder on them than it was for the men. But the hardness actually worked out in a certain way that shifted the balance of power, and we'll see that in the law. The distance between the homes required a partnership between the man and a woman that you typically didn't see in the more settled areas of the East Coast. You're out there by yourself. Frequently, the man would have to go attend to whatever business or hunt. The wife is left there alone. So there's a partnership there at a different level that you don't see in the East Coast or even in Europe. The other thing that's often ignored is the marital options. If it's an 80-20 ratio of men to women, the women got a lot of options to choose from. And so you'll see that as we talk about marriage and divorce laws and how lax they are, the ability to move. If somebody is not great, there's an option there. Lastly, the fact is perceptions matter in the shape of the law. The people that lived here understood the realities. They understood how tough it was. And so if you could stand that and you could be productive, it didn't matter if you were a man or a woman, you were counted as part of the community. And so what you see among the original settlers, even though they weren't close to each other, is a camaraderie that later came out in jury verdicts that we'll talk about. As new settlers came in later on, some of that changes. As it becomes more populous, yes, things change as they do as you get more, I'd say urban, but it's not exactly urban by our standards. So all of these factors are going to play into how the law adapts and then how it shifts some of the balances. That brings us up to about 1836 and the Republic. So we all know April 21st, 1836, we win the Battle of San Jacinto, we have the Republic, and this is where most history books stop. We stop here, we pick up at statehood, and off we go. What we ignore, though, is the fact that you've got to create a whole new country. You have to have courts, but what's different in the Texas Revolution is that you've got differences in the laws. When we split from England and the United States had that war, all the colonies had been on the same system of English law. You had existing judges, you had the similar thing across the board, everybody knew what it was that eventually became American law. The difference in Texas is, before the Republic, Spanish law applied. Many of those settlers had lived 10, 15, 20 years and had adopted that law and balanced it against their knowledge of the American law. What's better? What's not? Do we piecemeal it? Do we do it whole? How are we going to apply these laws? What's a court going to look like? During the Spanish period, you didn't have a court as we understand it. The local alcalde frequently was the only judge. You had local councils. But the Spanish version of a court is very different than the English version that was being used in the United States. And lastly, of course, you've got a vast area. How are you going to enforce it? Most of the law enforcement is the Rangers, and they're somewhere up in North Texas dealing with that situation. So how does all this affect women in a legal way? And really in two big ways, which is what we're going to focus on tonight. The first one is marital property. It's the idea of, is it yours? Is it mine? Whose property is it? Land, cattle, whatever. That's the question. Second is in marriage and divorce. How can you get married? How can you get divorced? How do those laws stay the same? How do they differ from what we've got now? And we're going to see some surprisingly advanced positions on that. So first one, marital property. When the Republic happens, Texas has to decide between two systems. You've got the English common law system that was used in England and then the rest of the United States, and the Spanish law community property system. They're two very, very different systems of law and different systems of property. So under English common law, and the idea behind common law, by the way, is not that there's a statute, it's that similar facts should result in similar holdings. And so the idea of common law is that as you try a case, if you can establish similar facts, you should get a similar result. So whenever you hear about common law on TV or things like that, that's what they mean. And so that's why you look at series of cases, you try to analogize to those. So that's what common law means. But under this system, when the husband and wife married, they would become one unit. Sounds right. Man and woman become one, right? Except for the fact that the wife is subsumed inside the man. Under this system, the husband and wife merge, but the husband controls the entire estate. The husband can manage or even sell the wife's property, even if it was a debt he had before he got married. And if they split, the wife only gets alimony. He gets to keep the land and everything else along with it. So an example, let's say you've got a couple in Tennessee, Maryland, wherever. They get married. Father-in-law says, okay, here's a plot of land. Good luck, have a good time. Husband now owns the land. He can use the land to pay his debts from before marriage. He can accrue any debts during the marriage that he wants. He can use it however he wants to. His only obligation is to be a good husband. That's it. If he dies, the wife doesn't get the property. Under that law, the property would have gone to the other heirs, typically the oldest son. She's left with a 1/3 life estate. And what that means, if there's any genealogy nerds, you've seen the wills that to my wife, 1/3 of the property where she now lives during the rest of her natural life. The idea was she would be able to have 1/3 of the income from that property until she passed away. The expectation is the children or the sons will take over. That's the idea. In the event of a divorce, husband keeps the land. He can ask the wife to leave. All he has to do is pay alimony. So that's the English system. The Spanish community property system, on the other hand, is very, very different. And so this is what I like to call the 3 buckets. Husband has a bucket, the wife has a bucket. Together, they've got a community bucket. So this is very, very different. You don't merge into one. Everybody keeps their own property. Under this system, whatever you bring into the marriage or whatever comes to you by inheritance or by a gift remains your separate property. So you do that, what you build together after the marriage, income, property, whatever you have, is shared jointly. So let's say you had a farm, the farm produces crops and you have $1,000, you split it 50-50. Now under this system, it's not completely 50-50 because the husband has managerial control over the wife's property, but he cannot sell the wife's separate property without her permission. And if he messes it up, she actually has a claim against him for fraud on the community estate. So she can hold him to that promise. So let's take our same couple. Now they move to Texas, receive a land grant. Under this system now, the husband and wife own the land equally. All the crops and income are split 50-50. If the husband goes off and makes a bad deal, the wife has a claim against him. The cool thing is, if the husband dies, the wife is perfectly free to remarry, but she keeps the land as her own. So when the new husband shows up, she's got not only the property she brought into her first marriage, but all the property she amassed by the second marriage, which gives you leverage in the marital relationship because the wives frequently had more property than the husbands. If there's a divorce, wife takes her half and keeps her separate property. Now, the husband has no obligation to pay alimony, but the idea there is if the wife has half the property, then that should be sufficient to make it work. And it's also a real kind of a quirk if you get into old Texas law. You don't say the word alimony. Spousal maintenance is okay. Alimony is not because, well, let's face it, a lot of our founders had divorce problems back in the States. One question that always comes up when I'm discussing this is why? Why are these systems so different between English common law and the Spanish law? And it's really fascinating how far back the answer goes. So starting with the English common law, 2 gentlemen on the right, Richard III and Oliver Cromwell. When you go through English history from about the 1300s on up until the 1700s, England is pretty much at war with itself throughout that period. You have the Wars of the Roses, you have the religious wars, you have everything else in there. Everybody's vying for power, so those in power want to keep it. So they create a system that's going to keep the power going to the greatest winner. It creates the aristocracy, and that's how it evolves. But also because of that, English law stays a little undeveloped until the 1700s. In fact, we don't even have the idea of hearsay really until 1720s or so. Something we take for granted is that old. The Spanish, on the other hand, had a very different experience, and that's why we have Queen Isabella here. So when we think of Spain, we think of the entire Iberian Peninsula. That wasn't always the case. Up till the 1400s, the Moors from North Africa controlled most of the Iberian Peninsula, except for two kingdoms, Aragon and Castile. They always wanted to retake that land which they felt was theirs. And so King Ferdinand of Aragon struck a deal with Queen Isabella of Castile. Let's work together, let's get married and try to take back all of Spain. Now, Isabella's smart, and she negotiates what today we'd call a prenup. And she creates a deal. If we win or if we lose, I keep my kingdom, you keep your kingdom. Those are ours, it's our separate deal. If we win, we're splitting that territory 50-50. It's the very foundation of the laws that we have now. Now we know the Spanish ultimately did take over. Once they're gone, it becomes a frontier society. Husband and wife having to live together in this new territory with threats of violence all the time. So you see in the systems there that the roots of what we have now go all the way back to the 1490s. So back to the choice. What is Texas going to do? We've got a major influx of new people from the East. A lot of them lawyers. They know the law. They know the advantages. But you've got a large number of settlers who'd been here before. They experienced it. They had children. They had wives. They had debts. They had the whole thing. They debated 1836 with the original Constitution, debated again in 1840 when things settled down, and again in 1845 with statehood. Community property wins hands down every time, which is really remarkable. In the cases and in the realities you see, the opinions, the judges and a lot of the people recognize frontier realities. It doesn't make sense to have a common law system where everything's vested in the man when the women are equally a part of this. With it is the idea of being a Texan that we talked about, the perceptions. If you earned it, by golly, you get it. That was the attitude. And so the protection is there. Now, let's be honest though, it's not all altruistic. There's also a benefit to the husbands. If the husband brought debts from the United States, they can't burden the community estate. So if the husband comes down and marries a wealthy widow who has a ton of land, oh, well, so much for those debts, you can't take them. So if you're a debtor, which so many people were, it worked out better. So all around, that's the choice. The cool thing is, this is from the Constitution of 1845. So we had to create a new constitution and when Texas was admitted to the Union. This is the first time in United States history that a government has set out a document protecting the rights of women to their property. So Section 19, all the personal property of the wife shall be her separate property. Section 22, same thing with the consent, that if there is a community estate, the husband cannot sell it without the permission of the wife. If he does it, she's got a cause of action against him. This is the very first document in American history where a government has done it. And we often ignore that, we forget about it, but in 1845, Texas becomes the first government to recognize that. Another cool statement that I found comes from a Supreme Court opinion in 1851 by Chief Justice John Hemphill. We'll talk about him in a minute. And it's really fascinating to think about how forward-thinking this is in the 1850s. The husband and the wife are not one under our laws. They are co-equals in life. And you think about that in the rest of the United States, that wasn't the case. But in 1851, Texas is already saying, no, that's how we're going to do it. So under this system then, the marital property laws work out more in favor of the wife than they naturally would have in the United States. So just out of curiosity, it's always fun to see which states use this system or not. This is the current list of which states follow community property versus common law. So you can see a trend among Texas and the Spanish-speaking states, or at least those were controlled by Spain, they adopted community property. Now, the fun fact, if you look into it, is why Wisconsin? So everybody else, why are they doing that? Well, the answer is interesting. So Wisconsin came into the Union not long after Texas. They have their constitutional convention. They've got a frontier reality, and so they're looking for the latest and greatest improvements to the U.S. Constitution. What can we do? They found the Texas Constitution and said, hey, that sounds like a great idea. So Wisconsin is the community property state. Now, reality, though, is flashing forward. Almost all states have adopted some statutory version of community property law. But a lot of it came about starting in the 1900s, then eventually the 1960s. So when you look at it, Texas in the 1840s is already enacting what it took until the 1960s for the rest of the country to figure out. So next, marriage and divorce. We can talk about community property all we want to, but you got to get married and you may split up. So we got to go through those. Marriage in a place where you're spread out across miles is not what we think of today. You didn't really have established churches, particularly if you were supposed to have adopted Catholicism. And there's not exactly courthouses where you can go down and have a civil ceremony. So what was eventually the system people used was something called bond marriages. Now, it was sometimes used on the American frontier. If you see some things in genealogy, especially in the South, about reading the bands, things like that, some of the more Presbyterian communities would have that. The idea is that the couple would give bonds to each other, that we're going to stay together, and if we don't, I'll pay, name the amount, $100, $250, whatever. And as soon as a minister comes by, then we'll go ahead and formally tie the knot. And that worked. And for a frontier community like this, that system worked well. But what it means is, as you have deaths and divorces and everything else, you could potentially have a lot of issues. Where is that couple actually married? If they're not married, what's the status of their kids? Are they illegitimate? Do they have any rights? What are they? And Texas said, you know what? That's the reality, so they adopted it. So in 1841, the legislature looks at it and formalizes all the old marriages. If you had a bond marriage, if you had something similar to common law, all that was recognized, meaning that all the kids would be legitimate and they had full rights of heirs under the property laws. And then once again in 1847, Texas gets out in the lead of the rest of the country. They recognized the idea that people could commit to each other, live together forever. Everybody recognizes them as husband and wife. They just didn't have a formal stamp of approval. And so we adopt essentially what becomes common law marriage. It's the first time it's set out that you can do that. There's certain requirements, have to be actual agreements between the two parties to be married. That one's very important. Living together for so many years, holding yourself out to others, and a couple other legal requirements about how long you had to be together. But once again, in 1847, we're already adapting the laws to meet the realities, which was that couples are moving into the frontier. There's no way to get married, so we're not going to force them to it, and we're not going to jeopardize them because they couldn't. So the law adapts to that unique situation. Divorce is equally as different. Now, at the time, especially during the colony period, divorce was prohibited by Mexican law, which was an extension of the Catholic prohibitions. So technically, you couldn't really get divorced without going through the Catholic procedures. America was very similar. To get a divorce in most states in America, you actually had to go and have an act of the legislature to be divorced. So eventually, when William Barrett Travis divorced his wife after moving to Texas, it actually had to go through the Alabama legislature, which to even get the bill to the legislature in various states, you had to know somebody, you had to know a congressman. Legislatures didn't meet all the time, so this was a difficult procedure. But in Texas, we recognized that just doesn't work on the frontier. Sometimes things don't work out, given the realities of it. So in 1837, the legislature actually allows divorce. It doesn't specify the grounds, but they actually authorize it, which is something for the first time that's done in the US. Now, the important development, though, is in 1841. So again, why 1841? Well, it's because the first 3 or 4 years we had a whole problem with Mexico and laws weren't stable. So we had to revisit that in 1840. See, if you keep saying 1840 in this presentation, that's why. But this one's really important in a couple of ways. So the legislature authorized divorces, and they specify the grounds: cruelty, abandonment, and adultery. Those were fairly common mentioned in other cases, but for the first time it's formalized. Now, the important thing, though, is the legislature recognizing how we're going to enforce this. The legislature can't take all that time dealing with the situation, so for the first time, they authorize courts to grant divorces. That's something new for the entire United States. The courts, because by then we have them somewhat established, are closer to the people. It's much easier, it's much more flexible. Now, the interesting thing, though, about the divorces is that frequently juries get to decide the questions. So this is why the frontier perceptions matter. Because the juries are made up entirely of men, and they're looking at the situation of a divorce. If the husband has not lived up to his obligations as a frontier man, but the wife has, guess who they're siding with? So it's a very interesting concept that we're this far ahead of the rest of the country in putting that perception and putting that power into the courts that are right there, instead of forcing everybody to go through the legislature in Austin or Houston, whichever it might have been at the time. Another interesting part about this is how the legislature defined cruelty. And you're talking about a violent, cruel society. So first one, rudeness and incivility, probably happen every day. Unfound charges of unchastity. This one came about because in a frontier society where the husband's gone a lot, if the husband wants to get out of things, you can blame the wife for that visitor that came by. So that's why that one's in there, but they can't be unfounded. The third one is really interesting to me. Physical assault of children from a previous marriage. Then in the 1840s, they already recognized that the stepfather or the stepmother may not be that kind. And so they're going to step up and protect the kids, which is really interesting for the 1840s. Next one, habitual drunkenness that prohibited attending to marital obligations, which you've got to wonder how drunk you had to be in that day and age. And the answer is it has to be more than 3 months. There's actually a Supreme Court case, again by Justice Hemphill, where a gentleman spent 3 to 4 months basically on a bender in Galveston. The report said he was being rude to his wife, he wasn't doing anything, but the record wasn't clear, and so Justice Hemphill said, 3 months, maybe not enough, I need some more information on it. But if it was 3 years of drunkenness, that would probably do it. So there's your answer for how drunk he had to be. Lastly, battery or verbal abuse threatening violence. Again, violent society. There's a famous case where the husband tried to divorce his wife because she attacked him with an axe. That worked. So interesting statistics here, because everybody always wonders, okay, well, you could get a divorce, but did anybody actually do it? And the answer is, yeah. So from the time around about 1840 or so up until about the 1850s of the Supreme Court divorce appeals, over half of them were initiated by women. So they were definitely using this. In 1845, the 11th District Court in Harris County, all but one were women. So another cool thing, the 11th District Court still exists in Harris County. If you remember all the Ike litigation, they were in that court. So it's still there today. So the records are still around. Then in 1860, at this point, we're fairly populous as a state. We're right on the eve of the Civil War. Women filed for divorce twice as much as men did. And so what you see working through is the perceptions mattered. The women have a lot of available spouses. They can change. If the husband doesn't work out, they can move and trade and make a better life. And so we'll go through some of those in a minute, but it's a very interesting, very modern look at how things worked back then. So we're going to tie it all together with one case. Marital property and community property. The case is called Carroll versus Carroll, 1858, out of the Texas Supreme Court. The situation is that two people, Susan and Nathaniel, come to Texas in the 1820s. Both of them leave their spouses. Both of them have kids by the first marriage. They take up. Neither of them had divorced. So Susan's kids stay with them. Susan and Nathaniel stay together from 1837 to 1853 and built a fairly substantial estate. During the time, though, Nathaniel didn't have any contact with his first family, who were somewhere deeper in East Texas. So Nathaniel passes away, substantial estate, leaves everything to Susan. So under law, she would have already been entitled to her community property and her separate property, but now he's giving her everything else. So all of a sudden, out of the woodwork comes the first son by the first marriage and says, oh, no, you were married to my mom. That's illegitimate. Dad, that doesn't work. He must have been insane. I'm challenging the will. That sets up a big challenge. Trial court looks at it and said, he's got a point. So the husband's separate property may not be hers, but she appeals, which brings us to Chief Justice Hemphill. Chief Justice Hemphill at the time is very well worth mentioning because of all the opinions he had. And he's also just a fascinating character in his own right. So if you've heard Justice Wise or some of the others that have spoken here talk about Justice Hemphill, he's a fascinating character. So he's born in South Carolina, studies law in Pennsylvania, eventually comes to Texas in 1838. Once he gets here, though, he realizes this is a different place entirely. So he studies the Mexican law, becomes an expert on Mexican and Spanish law. He's a very good American lawyer, but now he adds that to the repertoire. He also becomes fluent in Spanish, which also helps him translate those laws. Studies every aspect of it. He travels across the state. If you've heard of the Council House fight, that was his courthouse at the Council House fight. He was involved in that. But very forward thinking. And so some of his opinions, the one we saw earlier about the women and men are equal, that's him. The other thing a lot of people don't talk about because they focus on his jurisprudence, he actually had an interracial marriage in the 1850s. It didn't, it was clearly not popular, but he had it. And so a lot of his opinions that you see are very forward thinking. They're very well thought out, drawing from fairness principles, either under Spanish law or American law, whichever fits. And let's be honest, he's trying to hack the law out of the wilderness and dealing with two factions, the new group from the United States, the original settlers. It's not an easy job to do. So now, Susan and Nathaniel's case winds up in front of him on the Supreme Court. So, question is, does he go with the trial court or does he favor Susan? The winner's Susan. He writes an opinion and goes through the whole history of the relationship, why the trial court's wrong. But the best part of the opinion to me is this discussion where he talks about the fairness. By her labors and toils, she committed to the accumulation of the estate. At the time of the marriage, they had nothing. They built it together. Their gains were the result of the joint industry, thrift, and economy, and she's reasonably entitled to a share of the proceeds. That's really cool to think of that in 1858, the Texas Supreme Court is recognizing that. They're not going to stand on formalities. They're not going to stick with an English common law system that didn't work then. Instead, he recognizes the frontier realities that he had seen and experienced and realized that they had committed and worked it together. She was a partner in that, so she deserves the rest of it. So it's very fascinating to me that 1858, we're already here. Now next, I want to shift over and talk about some real stories. We've talked about the law in the abstract, so let's talk about some real people. First one, this goes back to the 1700s. A lady named Rosa de Bali, also known as La Patrona, down in the valley. So this is under Spain, and under Spanish law, she inherited land from her father, and then eventually from her husband when he passed away. Altogether, in 1798, she has 642,000 acres of land, which is basically most of the valley. considered one of the first cattle women because they were really doing the modern version of ranching down in the valley at the time. Highly, highly respected and still a legend in the valley to this day in her own right. Going forward a little bit, some of y'all may have heard about Emily Austin Perry. Stephen F. Austin's sister eventually moved down from Missouri with her husband, except when Stephen Austin dies, he has no kids. He leaves his entire estate to his sister. So under the community property law, that doesn't go to her husband, that's hers. That made Emily, because of her brother, the largest landholder in the state of Texas. And there's nothing anybody could say otherwise. So her husband passes away a little bit earlier than you'd probably expect, leaving her by herself. So she becomes an autonomous businesswoman. Between her land grant and all of Austin's land grants and everything else, she manages this estate for decades and becomes an autonomous businesswoman and leaves quite a few very interesting books or journals. Next, Jane Long. I think a lot of people have heard of Jane, lived primarily down in Richmond. Story is that her husband came down in the 1820s, tried to filibuster in Mexico. That didn't work out so well because he didn't come back. Left her by herself. She had a baby by herself down on Galveston Bay. Made it through all of that, and she never remarried. But she got her land grants, developed her own business, and never remarried. But throughout this whole period, even though she was supposedly romantically linked to everybody from Mirabelle Lamar to Sam Houston, she never remarried, but she was highly, highly respected by the community and built her own business and kept things going. This is interesting in Houston. So two ladies, Pamela Mann and Susanna Dickinson. And if you heard Justice Wise, he mentioned Pamela Mann. And if you Google her, there are legends galore about her. Now, her origins are not exactly clear, but a lot of historians think she was probably Almiron Dickinson's sister. Now, Almiron was one of the Alamo defenders, which explains why Pamela and Susanna are tied together quite a bit when you look at the legal records. So Pamela had come down. She goes through 3 or 4 divorces. But she builds up her own business and her own hotel, which is at this spot now in downtown Houston. So if you're down on Market Square in downtown Houston, this is a Barnaby's now. The La Carafe bar is right over here. The cool thing with Pamela is, despite all of the divorces, she has several court cases. Every time the jury finds her either innocent or they find in her favor. And in fact, even one time she got charged with forgery, convicted, which at that time forgery was a capital crime. The jury wrote to the governor saying, yeah, we found her guilty, but we think she should get off. So I love that jury because they actually followed instructions first and then tried to find the clemency. So she was let off. And in fact, then later when her son got married, one of the guests of honor was President Sam Houston. Susanna Dickinson at the same time, not as, let's be honest, she had a very tough life after the Alamo. Husband died, but she got to keep the property. Now, I don't know what happened to it. I'm trying to look into that because that land grant would have been hers. But eventually she moves in with Pamela. So she lives down here for a while. There's some debate about what exactly her role was there. But in any event, she has the same experience. After the Alamo, she has to find somebody to help, marries a guy who beat her daughter. She divorced him. Not a problem. She was able to get out of that circumstance, keep her property, and move on. Eventually married her final husband over in Austin. That house is still there. And so even though her life was difficult, she was able to make those moves that the marriage laws and the community property allowed her to do. And ultimately, even though it was rough, she did have a pretty good end to her life. If we keep going forward into the 1850s, you see the same trend. Anna Martin immigrates from Germany with her husband in the 1850s. He dies fairly quickly in 1870. Once again, all the property is hers, and they had quite a bit of land in West Texas. Now, she's smart, and early on, she saw barbed wire for the benefits that it had. And so she starts buying it up and becomes the largest dealer of barbed wire in West Texas during the cattle boom, so she amasses a fortune. Then she turns around and uses all that money and all that cash to help found and become the CEO of a bank. Now, some people debate it, but she very well may have been the first female founder and CEO of a bank in American history. And I love this quote from her that I heard men say, oh, she's only a woman, but I showed them what a woman could do. So it's pretty cool that you see this coming forward even now using the same laws. Last, but certainly not least, this one's kind of cool for me because this is where I work downtown. Melly Esperson. So Melly and her husband Niels was an immigrant from Norway. They married, eventually moved to Texas, late 1800s, early 1900s. Niels a hard worker. He's also smart, and he figures out that oil stuff they just discovered, that looks pretty good, so they make a fortune. They become some of the first people to get in on the very first oil boom. But during this, they don't have kids, so Melly and Niels work together in everything. Melly becomes very involved in downtown Houston, helps found 2 theaters. The Palace Theater downtown at one time was hers. Niels passes away too young, and so Melly wants to create something to honor him and decides to design and create the Niels Esperson building right here. 27 stories tall, it's the first skyscraper in downtown Houston and the second in the state of Texas. All designed with him in mind, and so if you go in the lobby, there's a statue of him, all dedicated to her husband. The cool thing is, she couldn't bear to be separated from him, so she decided she'd build her own building with her name on it, the Melly Esperson building. But when she's building it, she didn't want to take away from her husband at all. She just wanted to stand by his right where she'd always been throughout his life. And she was able to do it and run her businesses up until the very end of her life. Her fortune eventually became a trust. Trust still controls part of the building. But overall, she was able to do it because of the laws that were in place when the Republic created, and they trace all the way back to the Spanish times and the community property laws. So it's very fascinating to me as a lawyer that you can look now at a building in downtown Houston, trace it through the Republic, through the frontier, across the ocean, all the way back to 1492. And somehow our founders had the bright ideas on how to have these laws and adapt them to the frontier societies in ways that would actually come out in a better way for women in that type of society. So if you're interested in reading some more and want to look into it, these are a couple of free resources. Tarleton Law Library has all of the Texas constitutions and a lot of the historic documents. So you can look at some of the debates that happened, read the letters, every one of the Texas constitutions from 1836 up until 1845, which we still have. All of those are in there along with all the records. The Texas Supreme Court Historical Society is also just a treasure trove of information. It says Lawyer Society, but all of their journals are free. So they've got a great search feature. If you want to look for anybody on there, you can pull up their journals, learn more about it. Very good website for anybody interested in Texas history and the law applicable to it. So with that, that's why I called it By Her Labors and Toils, because it really was, and it resulted in very forward thinking and a good result for a lot of women. So with that, I'll turn it over for questions. Yes, ma'am.
I have a question. I always assume that's how your speech is how it works. I want to know why then, when my parents died, they had 3 daughters, no sons. Everything was divided equally, and they made provisions, written provision in their wills, that those inheritances were to go strictly to their daughters. I guess not that they didn't like their son-in-laws, but they wanted their daughters to be sure to be provided for.
Sure.
Now, when in order to receive that, we were all asked to, well, actually, husbands had to sign off on that. Now, if that was the case, why is it, I was highly insulted, and so were my sisters. We couldn't get it unless it was signed off by the husband.
It's smart lawyering. So remember your bucket, my bucket, and the community bucket? You can make a gift to any one of those 3 buckets. And so that's what they're doing. So your dad could have given your husband a gift that was his separate property. So he could have left him a shotgun, golf clubs, whatever. That could be his separate property. He can give a gift to you. Whatever it may be, he can give that gift to you and you only. That's your separate property. Or he can say, here's my property, and it winds up in the community bucket because you got that then. So what they're doing with that, and by requiring it, is just making sure everybody's clear on this, that inheritance is being made to the women as their separate property, only theirs. And actually the Carroll versus Carroll case gets into that because Chief Justice Hemphill talks about the will was a little bit vague on that point, and he wrote over it, but that's why you would do something like that. To be crystal clear, it is only going to the women. So that way there's no questions at all. So that's belt and suspenders lawyering.
Well, I was lucky enough to have Felipe agree.
Yeah.
Well, if he didn't agree, could she still have gotten it?
Sure.
Yeah, he did.
Yeah.
That was their premise, and see, I didn't understand.
Yeah, you could. It's just being very, very clear, and by the attorney that drafted that, to just, they're basically, what they're doing actually is depriving themselves of a future lawsuit. So good on that lawyer for trying to do that. So, yes.
Okay, my ancestor had an 1880 divorce in Harris County. So what would that look like? Would there have been witnesses in court, accusing people of adultery, and would there be a sleeve in the courthouse records still?
So the first question, what would it have looked like? It depends on the case. If they decide that that's the way it's going to go, there probably could have been a trial. I would think there would be, depending on how much one of the spouses wanted to fight it. The records may still exist. You can find those. There's a good treasure trove at the South Texas College of Law Library. There's also one at it's the 1910 courthouse downtown. But one person that would know exactly where they are is a guy named Judge Mark Davidson. Judge Davidson is the guru on all things Houston legal history. So he'll be able to help find those for you. Sir.
Do you have an idea of how much Stephen F. Austin's sister owned in land?
It was well over 100,000 acres.
100,000.
Yeah, she and her husband had taken their own land grant for a league in the labor, had purchased several others, and so at the time Stephen Austin died in, 1837? 36. Then he still had tons of land that had never been given out as colony grants. So all of that went to her across multiple counties. So when you look at her wealth and then how she and her husband worked together to manage it, it's really fascinating because she never expected to be put in that position. And so she not only made that work, she taught a local school near her. Journals are just fascinating. Some of her observations about Texas history are just really, really cool. But yeah, it would have made her the largest in Texas by far.
To follow up to, sometimes y'all been here for programs we do, because Stephen F. Austin was a bachelor who's running this land impresario project for Mexico, he's being paid in land. So the land that ends up going to his sister, who that heirs, right, is basically the stuff that Mexico granted to him in response to him bringing immigrants and settlers here. That's his paycheck at the end of those contracts. And when you look at our map, particularly that connected map, it's both in the current temporary exhibit and in the desk, the virtual desk in there, Stephen F. Austin's name is all over his colony because he's cherry picking places that he predicts will be valuable for future development, ports or city locations. So he owns a ton of land. It's actually kind of a tragic story in his family. He had tried to leave some of his estate to a nephew who was named for him. And that nephew died before he came of age, just had a sister who left him.
Mm-hmm.
At the time, though, that Mexican land was very cheap. I'm sure the Mexicans thought that they were giving away nothing.
Sure. Well,
and now we go like 100,000 acres. Right?
Yeah, so Mexico knew what they were getting out of that whole process, but Chris kind of alluded to this when he brought up Emily. A lot of the heirs of Emily Austin and the Bryan and Perry families ended up owning land that became a key linchstone to becoming ranching families or ultimately the cultivation of oil and gas on their properties. These are all people that did very well by virtue of having a large stake in land.
Yeah.
So what did Emily do with all that?
She made a lot of money during her life at a time when cash money wasn't something you had a whole lot of. So she did that, had a lot of nieces and nephews and her own kids. And so she took care of all of them, took care of a lot of the people around her. And then ultimately the land got pieced out throughout the family into the various branches.
So then, like, when you say she made money, like, what did she do? I mean, different things, like cattle on some and stores on some, or what?
Mainly reinvesting it into the land. So cattle, farming, timber, and then also a lot of the cash. She built a schoolhouse nearby, kept her house very nice for the time, which a lot of people weren't able to do with the cash. You have to do it on loans. So she was able to do that, make tons of donations to the neighbors, and really just a community pillar is what it became.
The original burial site for Stephen F. Austin there at the Gulf Presbyterian Church in Jones Creek. That's right on the edge of the Peach Point Plantation, which was Emily's homestead. She and her husband when they first came to
All right. Well, if that's it, I sure appreciate the time. It is certainly an honor to be here and to talk to y'all. Thank you so much.